This episode of News from Poland Business and Law will be devoted to the legal aspects of supply chain cybersecurity. The subject will be discussed by Jakub Barański, advocate and partner in Wardyński & Partners dispute resolution practice.
As usual, our program is addressed to foreigners who are members of management boards in Polish companies and to foreign investors. Cybersecurity is one of the biggest challenges currently faced by the business community. Many firms are already implementing measures to ensure their protection against various forms of cyber risks. Your business may be among those prudent few, but is that enough? What about the partners you work with, your suppliers or service providers? Are you certain they are as secure as you are? Is your supply chain as secure as your own infrastructure? In this episode, I will try to answer these questions and discuss the topic of supply chain cybersecurity, why it matters, what it means, and how to achieve it, particularly through drafting proper contracts. According to a recent study by Accenture, almost 40% of businesses affected by cybersecurity incidents in 2022 have suffered harm not because of a targeted attack against them, but rather due to collateral damage, resulting from an attack aimed against another party altogether, someone from whom they have bought goods or acquired services. A good example of how one cybersecurity incident can cause ripple effects throughout the entire industry, or even across different sectors, was an incident that took place in late February 2022. In the early morning of February 24th, the eve of the Russian full-scale invasion of Ukraine, actual fighting was preceded by widespread cyber attacks aimed at disrupting internet access throughout the country. The attacks targeted particularly satellite communications, on which the Ukrainian military was believed to have been heavily reliant. One attack involved the use of a strain of destructive wiper malware, designated as Acid Rain, which was designed to remotely erase vulnerable modems and routers across Ukraine. The attack, however, also rendered inoperable the KA-SAT satellite, used by its operator, Viasat, and several other ESPs to provide satellite internet access in Central and Eastern Europe. The consequences of the attack were significant, affecting thousands of users across the continent, including in Poland and Germany. Among those affected was the energy company Enercon, who, as a result, temporarily lost the capability for remote monitoring and control of almost 6,000 wind turbines that operated in Germany. A massive recall action was needed to restore service, replacing nearly 30,000 compromised modems and routers, which suffered irreversible damage due to the malware. There are other examples of such incidents, including attacks that resulted not just in collateral damage to third parties, but were specifically designed to infiltrate the victim by exploiting vulnerabilities in the security measures implemented by its suppliers. The more complex a supply chain is, the more opportunities of this kind it offers to potential perpetrators. That is why prudent organizations are taking steps to ensure not just their own resilience to cyber attacks, but the ability to counter potential risks to their business partners. This practice is called supply chain cybersecurity, and it is becoming ever more important. But what does it actually mean? What should you do to achieve supply chain cybersecurity? And is this something that lawyers can help you with? At its most basic, supply chain cybersecurity comes down to 3 steps. First, you identify who are your most important suppliers and in what way you are connected with them. You should identify and understand the type of interactions which specifically occur between your companies, particularly which of your resources and data they have access to and which of your operations are dependent on them. Second, you need to assess the threat landscape, the type of cybersecurity risks your partners are likely to be facing, and the impact those risks might have on your own business. You want to understand the type of issues that can occur and the time and cost that will likely be necessary to restore normal operations after an incident. You also want to assess the type and level of security measures that your partner has already implemented to see if and to what extent they correspond to the risks you identified. The third and final step is to design and help implement an adequate risk mitigation policy by your supplier, either starting from scratch or building on what was already in place, as well as introducing mechanisms that will ensure compliance with the policy in the long term and the risks you identified. Supply chain cybersecurity is a multifaceted process, and it works best when specialists from different relevant areas, such as management, IT, and legal, are involved throughout it. The part with which legal counsels can help you the most with, however, is the last stage, the actual design and implementation of the new cybersecurity policy. In particular, your legal counsel can help ensure the policy will be complied with by drafting an appropriate cybersecurity clause that will be introduced to the contract. A well-drafted cybersecurity clause can contain a number of different provisions that assist with this goal. The most basic ones would include a requirement to actually implement the policy designed during the process, as well as a general obligation to maintain safeguards and controls adequate to the expected security level. It should also define the sanctions for non-compliance, such as contractual penalties or liquidated damages. Depending on the circumstances, the clause may also include other provisions, addressing different types of concerns that are specific to your relation. For example, you may wish to include reporting obligations, requiring your partner to notify you of incidents within a given time frame and according to a specific format. This can include other information obligations as well, such as a requirement to isolate and secure specific types of evidence in case of an incident, or to conduct a forensic analysis as soon as possible and share its results. These types of provisions may be particularly important if you yourself have certain reporting or notification obligations, required either by law or a contract with one of your own clients. If the nature of risks that were identified justifies it, you could also include provisions requiring the supplier to implement and maintain a business continuity plan, ensuring that business operations will return to certain predefined levels within a specific deadline after an incident. If you expect your business partner to subcontract or outsource certain work himself, you may also consider including a downstream clause in the contract, requiring him to ensure that his own suppliers maintain similar standards or undergo a similar due diligence process before they are accepted as part of your supply chain. Finally, you could consider including provisions requiring your partner to conduct regular assessments of the policy and the threat landscape to identify any vulnerabilities and take steps to address them, keeping the policy up to date. A right to audit compliance with the policy, accompanied by an obligation to maintain documentation of measures taken to implement it, will also help to ensure the policy remains effective. Keep in mind that the aim of the entire process is not to shift the burden or responsibility for cybersecurity to your suppliers. On the contrary, supply chain cybersecurity works best as a collaborative approach, with both parties working together to address a mutual concern and equally benefiting from it.
Thanks for watching this episode. See you soon.